Yes, good evening to everybody, to the students of the Advanced Private International Law, Karibustana for the conflict of laws, and today that we are going to deal the conflicts in the Transfer of Property Act and where the one of the component is succession. Or we can say inheritance. The difference between a succession and inheritance is we inherit the property through the succession. Is it clear?
Yes, Prof.
Yes, very good, very good. Could you able to read what I posted on the screen? Is it Madogo Makubwa?
We cannot see it.
Okay, because I would like to see how I can magnify it. Tumia bongo. Nini?
No display of the document, sir.
No display? Okay, just now I will see. There is a display of document. It is clearly shown over me to me. There is a display of my document. Okay, now I cut my video so that you could see the prompt. Yes, now you tell me. Could you see my document?
Yes, I can see now.
Yes. See, the purpose of making it, now first you should be aware of what is going on in Tanzania, what is the law would be applicable in Tanzania in case of the Christians, in case of the Islamic faith, or any other person. For any other person, definitely it is there. Indian Succession Act would come into the picture. And for the Muslims are concerned, yes, there is a Sharia law is there. Always they will follow the Sharia law. And do you have the Qazi courts in Tanzania?
Kadhi Court
Yes.
I think Zanzibar.
in Zanzibar.
Zanzibar, there is definitely. Suppose if a case is filed in India, in mainland of Tanzania, and who will decide the case? The same courts as usual. They take the expert opinion of the Qazi and they will decide the case if there is no separate court in mainland of the Tanzania. Am I right?
Yes, Prof.
Because when there is no Qazi court, if any matter comes regarding the Islamic inheritance or succession is concerned, where the one of the party hails from the other country, at the time, to my knowledge goes over there, they will take the expert opinion of the Qazi, that who is well expert in the Sharia law, and they will take the opinion and is the authentic one, and they will decide the case. Yeah, because such a situation very rarely come. If it all comes, they will follow that procedure. Anyone can read what I posted on the screen? There is an introduction.
Number 1, introduction. Tanzanians' inherent laws are in urgent need of reform. Both customary and Islamic law, the two predominant systems of interstate succession in Tanzania, limit women's inheritance on the basis of their gender. Under customary law, a widow is generally denied inheritance altogether. Her share is to be carried for by her children, just as they cared for them. Daughters inherit smallest share with attached restrictions, and under governing Islamic law, women only inherit half as much as the men. Tanzania's inheritance law thus impoverish women and leave their survival at the mercy of men.
Yes, enough. See, the point here is, when they say both customary and Islamic law, the two permanent system of the interstate succession in Tanzania. But it is very clearly there the Quranic shares will be applicable in the Sharia law. And it is clearly said that 2 shares for the male and 1 share for the female. Because the female who got married or went to the other place and she is having the shelter of the husband, property of the husband, at that instance, Even though she got married, only one share will be given to her. For the male, 2 shares are given because he will take the responsibility of the family, take the responsibility of the father and mother, brothers and sisters, those who are not married, and hence 2 shares will be given to the male. It is very much clear. In any case, there would not be any total 1 share. All 1/2, 1/6, 1/4, like that shares are there. It is 11 shares are there, if I not be mistaken, the Sunnila, and 9 shares are there in the Shiala. So it is as per the Islamic way, it can be done. There is no dispute at all. And when the matter comes to the immovable property, then the law of the land, that is the lex status, will be applicable. Where the movable property is concerned, either for the transfer or by any other means you want to convey, either by the sale, either by the gift, or you need to inherit it, whether there is a will or there is no will, at that instance, as I told you that Indian Succession Act will come into the picture if the other people are there, like the Christians, because there is no Hindus here. If the Hindus also here, their Hindu Succession Act will come into the picture, because the Hindus, Jains will come, Buddhists will come, Sikhs will come under the Hindus, except Jews, Christians, Muslims. And the Parsis, they are having their own system. And for Parsis also, there is a separate law, or the same law would be applicable. But there is no question of dispute over here in Tanzania, because the dispute is only come between the two only. Number 1, Christian. Number 2, Islam. So here that what I want to clear the explanation is, inheritance law is urgent need of reform, definitely. Because when you see the customary law, a widow will be denied and the children will be given over there. Both customary and the Islamic, the 2 permanent system of the interstate succession in Tanzania, limit women's inheritance on the basis of their gender. But in Islam, there is no discrimination. It is clearly mentioned there, and justification also given. Under customary law, a widow is generally denied inheritance altogether, but if the children are there, there is a different share in the Islamic law. If the children are not there, there is a different share in the Islamic law. To my knowledge, 1/4, if the children is not there. If the children is there, I think it's the 1/6 or 1/8, it will come into the picture. Under customary law, a widow is generally denied, and he or her, here the square brackets say, either you can read as he or her, both are applicable over here. Share is to be cared for by her children, just as he cared for them. Daughters inherit the smallest share. I told you that because they are going to marry it, or they married also, and they will get the only 1 share, and the sons will get the 2 shares. And with the attached restriction, and under the governing Islamic law, women only inherit a half of such a man. But all property in the Islamic law, when you see it, there is no ancestral property, there is no self-acquired property, and all property is deemed to the matrimonial property, and where the husband and wife is having the equal rights, provided, again the question comes, if the children are there, if the children are not there, how the law will be applicable? If the father is there or the mother is there of the deceased, and even they also be entitled for the inheritance under the Islamic law. Tanzania's inheritance laws thus impoverish, means not that much a good, very clear or perfect women, and leave their survival at the mercy of the man. It is not very much justification will be given over there, but it is the mercy of the man would be there. But when you come to the Islamic law, there is a clear-cut provision is there. Is it clear? Say yes.
Yes, sir.
So the effect of these discriminatory laws is further magnified with the procedural inequalities, exploitative practices, and the spread of the AIDS. Procedural laws favor the selection of the male administrators, even if they are distinct relative of the deceased. But overall, these are all the literature which you are given over there. But what we want is only 2 things. What is that? If the movable property is there, how the succession will take place? If the immovable property is there, how it can be, which law will be applicable? And if it is a Muslim, if it is a Christian, if it is any other caste, what law would be applied over there? That is our dispute. Is it or not? Say yes.
It is, sir.
Yeah.
Yes, sir.
So now, Tanzania's inheritance regime violates the women's fundamental rights to the equality. Only customary law is there. At the time, there is inequality would be there. Property in an adequate standard of living, family and dignity under the Tanzanian constitution and a binding international convention. But the international convention clearly says over there. But the Hindu law, they say, if male is there or female is there, doesn't matter. Equal share. Even though she is married. I'm speaking about Hindu law. Because Hindu Marriage Act, it is there, and there the section 6 is, if I not be mistaken, that is made. Everybody is equally shared of the deceased property. Either she is married or unmarried. But only in the Muslim law they say, because she will go to the other house, hence she will get the property for the husband, and hence only one share will be given for the male, because he will take care of the children. I mean, dependents, father, mother, relatives, unmarried sisters, unmarried brothers, and everybody, because he is the head of the family. That's why the 2 shares are given to him. So that is the thing which I want to make it convert. In 2000, Tanzania amended the constitution to prohibit the discrimination on the basis of the gender explicitly. Equality is likewise the basic principle under the international law, requiring the modification of the Tanzania inheritance law. The committee responsible for the implementing the convention, the elimination of all forms of the discrimination against the women, that is the CEDAW committee, especially instructed that the allocation of the unequal inheritance shares, the widow and daughters, contravene the convention and should be abolished. They said, but I don't know how much that they are domesticated this one. So, the Human Rights Committee focused on the property of inheritance rights as requiring the particular attention to Tanzania compliance with the international covenant. Yes, they say widows shall have the right to an equal share in the inheritance of the property of the husband. A widow shall have the right to continue live in the matrimonial house. Women and men have the same right to inherit the equitable shares, their parents' properties. Of course, they are given, but how far the implementation is, only God knows. What about the implementation? Do they are getting the same equal shares? Yes. Give me the answer. Participants.
In which Prof, are you asking in which religion?
Yes, I'm asking the Christian religion. They do get the equal shares. Are you widow? Are you woman? Did you understand my question?
No, Prof.
Whether the woman will
No.
get the equal shares in Tanzania, like a man, in inheritance.
Customs differ, Prof.
No, sir.
What law would be applicable for the Indian Succession Act? For the succession for the Christians? Christians, Indian Succession Act, when there is no will, which law would be applied? Indian Succession Act.
Indian success. Yes.
What the Indian Succession Act says, whether the equal shares or the partial shares, 1/2, 1/3, 1/4, 1/6. If no one is there, if only brothers and sisters are there, they will get the Christianity equal shares, as far my knowledge goes. See, if you want to know Christians' inheritance, as per the Indian Christian Act of 19 in India, I uploaded what is the role of the Christians and how the Christians will get the succession where there is no will. Just to type my name and you write Christian succession, and you will get the videos, because I prepared the videos for the Muslims, Christians, and separately in the Muslim law, how Christians will be treated. I am sure the same thing will be applicable in Tanzania also, except the customary law. So Tanzania Law Reforms Commission explained discrimination in inheritance on the basis of the sex has received a critical judicial assessment. Not only judges, academic writers, politicians, and women's activities have decreed this appeal states of affairs. In Ephraim versus Pastori, the High Court characterized the restrictions on women's ability to inherit clan land as a oppressive and unjust law of the past, and the cause of women's suffering on the hands of the selfish clan members. So Tanzania government itself has called for the elimination of the customs and traditions with the negativity of the effect of development such as the discriminative gender practices in inheritance, and acknowledge the need to revisit, review, and abandon the outdated laws. Tanzania inheritance law are especially anachronistic in the light of the more recent statutes that recognize the women's equal property right. In fact, Tanzania women are economically better off if their marriage end in divorce than by the death of their husband. Okay, that is they are well off, when better off if their husband end in divorce than by the death of their husband. If the death is there, they are not going to get, but the divorce is there, yes, definitely they are going to get it. Suppose if they get the divorce over there, how much the amount will be paid to the wife, widow, divorced wife, and how much the amount will be paid to the children? Yes? Anyone? Only survival amount? Or any share
One
is there?
1/3 to a wife and 2/3 to the children.
Suppose the children are 3. It will be divided by 2 by 3 by 3?
Yes.
Yeah.
Yes, sir.
Because if children are more, we cannot get it more than that, because it will be equally distributed over there. If the children are minors, it will be the custody of the mother. Of course, it depends upon the best interest theory is concerned, whether the children will be the custody of the mother or the children will be the custody of the father. Yes, suppose the child is, think that a girl child is or boy child is 12 years old or 13 years old, both, whether they are the custody under the father or the custody under the mother.
Above 14, they will be under the custody of the father.
Below 14?
Under the mother.
Both a girl or boy?
Both.
Both. But when you see the Muslim law is concerned, they have given the Hanafi law a different type. There they says, if the boy is there, they say only 2 years. If the girl is there, 7 years. But if the vicious life the husband is leading, at that instance, if the mother's custody would be there, the best interest of the child, they will decide in that manner. Otherwise, mother is not custodian when they have grown up. It is the father is the custodian, even for the conducting the marriage of a girl. I'm speaking in Indian law. Whatever who will conduct the marriage? Suppose if she is marriage age, father will conduct it or mother will conduct it when the divorce took place in Tanzania. Did you understand my question?
No, sir. Can you repeat it?
But why you are not asking me? Unless I will ask you, then only, sir, can you repeat me? Suppose the girl is marriageable age. The boy is marriageable age. As per the CRC, the girl is 18 years, the boy is 21 years. Whose responsibility there for conduct of marriage? The divorced husband or divorced wife?
Person.
Person, sir.
It is the responsibility of the father, not the mother. Because father is the whole manager and he will take care of the children. Okay, now the question comes over there. For the girl is concerned, definitely the father will conduct the marriage. No doubt at all. Then the responsibility will be over. That way that he will make it out, depending upon the laws prevailing over there in the country. That shows an important role. That's why I said here, Women's Legal Aid Center, WLAC in Tanzania, Georgetown International Women's, all those things they have given. Whether what law is applicable over there must be very much clear. Matrimonial home, any household belongings, their property, joint ownership, and surviving the spouse, which receive the 45% of the, here they said, estate, and children 45%, and the parent 10%. Additionally, the clinical proposed bill is there. Law of the land will prevail when deceased domicile will be considered. So here in the article, analyze the current inheritance system in the Tanzania and advocates for the enactment of the Uniform and Non-Discriminatory Succession Act in order to meet the Tanzania constitutional and international obligation, they said. But how far it is made, I don't think that whether equal treatment will be given or not. But he made, there is injustice to the women, that is made it clear in this article. And if you go through the article totally, but what we want is how it can be made, which law would be applicable. That is our question. So, for the immovable property, it is very much clear that which law would be applicable for the immovable property? Yes? Participants, which law would be applicable for the immovable property?
Lex situs.
Lex situs, where the property is situated. Is it clear?
Yes, sir.
Is there any doubt regarding the mother? Who's your mother? There is no doubt at all. Doubt about?
The father.
Father. Now the question comes over there. For the movable property is concerned, it is the domicile of the person will be taken into consideration for the inheritance or for transfer of the property also. That means we follow the municipal law. What law is there of deceased domicile? That would be followed. See here it is clearly mentioned. Although three parallel systems of interstate succession operate in Tanzania, the choice of rule channel of the majority of Tanzanian citizens into the discriminatory regime. The three systems are customary law, referring to the traditional tribal law, Islamic law, and the Indian Succession Act. While the Indian Succession Act is gender neutral, both customary and Islamic law are discriminatory, as discussed in the detail below. Customary law is codified in Tanzania, where various statutes provide for the application of the Islamic law to be govern the inheritance of Muslims. Approximately 45% of the Tanzanian population. The Indian Succession Act consists of the codified English law from the 1865, improved to Tanzania from the India by the British, who exercised colonial power over both the countries at the time. The Indian Succession Act is in need of the updating to fit the needs of the Tanzanians and to bring into the modern era. Unlike in Tanzania, interstate succession law in both the India and the United Kingdom has been modified from the 1865 version. As explained below, choice of law and practical considerations combine against the application of the Indian Succession Act, and both customary and Islamic law deprive women of her inheritance solely on the basis of gender. But I made it very much clear that Islamic law is very much specific and there is no amendment to it. There is no change to it because it is made keeping the future use of the generation to generation. And I don't know whether you believe it or not. A women organization went to the court, went to the guard and say, sir, when you're taking part in the BBC, BBC means I already told you. What is the BBC? What is the
Body to
BBC?
body contact.
When the BBC,
Body-
yes, you are right. When the BBC, both can enjoy it. But when the matter comes to the delivery, why women should have to suffer? In the delivery, why a woman should have to suffer? Because the act is done by both of them. And she conceived. God told to this woman, please, I know what to do or what not to do. Please don't raise such a question again. I know why I did so. Then the lady came back. But the women organization, they said, no, we have to go to the God and ask. The equal pain should be there for the husband also. At the time of the delivery, half of the pain for the woman, wife, half of the pain for the husband. Then God again says, see, I know what to do, what not to do. Please, don't come again because your limited mind, you are thinking of equal rights to the man and woman. But I know what to do. And he rejected the plea. Third time she went over there. All the women organization to the God. God, you have to listen to us. You are discriminating. Half of the pain to the husband, half of the pain to the wife. Then God told, see, you are stubborn, being a lady. I know what to do, what not to do. Okay. But later on, you should not come and beg me. No, we don't come again to beg you. Okay, now, yes, granted. So whenever the delivery would be there in the village, half pain goes to the husband and half pain goes to the wife. Husband is in another room, he's crying, and the wife also crying because of the delivery, natural delivery. I'm speaking about the natural delivery. Okay, it is going on. The lady said, we won the case because in the BBC, both are enjoying. In the delivery, I am not only enjoying because she also suffered the same thing. They cried like anything. And there is a good celebrations. If one day, the wife is crying with the delivery pain, but the husband is not getting the pain. But who is getting the pain? Jirani. A neighbor is getting the pain. Who is getting the pain? Sema.
The neighbor.
The neighbor is getting the pain. So everybody astonished. How could the husband is not getting the pain? And the neighbor is getting the pain. So that gives the evidence that what is that evidence? What is the proof? What is the conclusion?
Baby.
The neighbor is BBC and the boy is conceived, not the husband. Is it clear?
Yes, sir.
Yes. Then it became a hue and cry in the entire village. How come this lady have slept with that Jirani and got the conceived? And the husband got the doubt. How could I am the husband, I should get the pain, and there is a hue and cry, and the whole families are disturbed. This incident happened 1 or 2 or 3. Later on, all the women organization again went, God, please forgive us with our limited mind, with our limited thinking. We asked such a thing. Please forgive us. Our life will be miserable now because the husband has left us, because I conceived with the another Jirani. So God told, woman, I told you already that you are having the limited mind. I know what to do and what not to do. See, then they rubbed their nose and they slapped their cheeks. They make the up and downs. God says, okay, I will excuse you. Now, only women get the pain. Not the
Not the man.
husband. What's a man?
Okay. Husband.
Husband will not get the pain. So, our mind, our thinking is limited. So, we cannot question the God decision. Is it clear?
Yes,
Is
sir.
it clear why I have given this story to you? Our thinking is limited. Is it? Say yes.
Yes.
So that is a gender
Yes, sir.
inequality, because in the Islamic law they say gender, a woman get the 1 share or the man get the 2 shares because of the justification they have shown over there. But Tanzania choice of law provisions favor the application of the discriminatory customary law to most of the Tanzanian and African origin. By statute, customary law regulated the succession for a woman, a person who is or was a member of the community in whose rules of customary law are relevant to the matter was established and accepted. In certain customary law, a woman cannot deal the property in proper way. And hence, a woman cannot dispose the property also. If a woman wants to dispose the property, her husband consent is must, number 1, or her father consent is must. In certain places, a woman cannot. But we'll say no, equal rights should be given to the women. No. The answer is, it should be given, but when the matter comes to the disposition is concerned, no, she cannot individually take such a decision. And somebody's consent is must. And I'm also having the opinion that, yes, somebody's consent is must, because her thinking is limited. She will not think about the long sustainable development. She will not think it. She will think only the temporarily on the spot. So customary law is thus the default in the system of Tanzania and African, but not European or Asia. It is a decent Tanzania from the African community, that the communities can escape the application of the customary law only if they can meet the requirement of the one of the 2 tests. They must either show that it is apparent from the nature of any relevant act or transaction, manner or life or business that matters is to be regulated otherwise than by the customary law. So when the enactment is not there, naturally we follow the customary law. But when their statute is there, naturally we don't give the importance to the customary law, but we will give the importance to the statutory law. So that the deceased professed Islam or Christianity and written or oral declaration or his act, manner of life, and they are intended to estate the administered according to Islamic law or the Indian Succession Act, or both of these tests are difficult to satisfy. See, merely becoming a Islam by keeping the name, it's not enough. You have to go to the mosque, you have to pray, you have to follow the norms of it. Then only you can be considered as a Muslim. If not, by keeping the name Ramazani, you cannot be given the right for the inheritance, but you have to practice also. Yes, in Tanzania also they will test it, whether he is merely by Muslim or merely by Christian, whether he practices also or not. If the whole village give the witness that and prove that yes, his practices, then he will be considered. Is it clear? Yes.
Yes, sir.
So the dispute, when it comes over there, which law would be applied, then we will see the municipal law of the domicile of that country. That is very important factor. That is he has given a lot of information, but you read it. But the gist I am giving is the thing, which prophecy that he is practicing, and what he is domicile for the movable property. It can be inherited or comes through the succession. Inherit the property through the succession. What are the prevailing law there in the municipal law in that country? That will be counted. And I told you already that if the child is illegitimate, whose domicile will be considered? Give me the answer.
Illegitimate, the mother.
Mother will be considered. So that, as we already discussed in connecting factors, and hence, and how the Indian Succession Act will apply over there. The Indian Succession Act applies to the Christians and all those European origin, while customary law is applicable to the African members of the community, irrespective of their religious affiliation, whether the Christian or Muslim. Indeed, the Tanzanian government criticized the inheritance regime applying the customary law, Islamic and Hindu law for its negative effect of the reinforcing the perpetuating racial and tribal divisions among the citizens. This different treatment between the women of African origin compared to the women from the Europe and Asia for further violates the equal protection guarantees to both the Tanzanian constitution and international law. Only customary law they will make it a difference in the Tanzania, but the Tanzania also emphasizing that equal rights should be given over there, like Asia and Europe. So there's the ancestral channels into the sex discriminatory inheritance scheme, which shown below the deprive her equality, property, inadequate standard of living, family, and production and dignity. Yes, it should be removed over there because there are many flaws are there when you see the customary law. But when a customary law is as a natural law, at the time, yes, it can be codified. So he has given the many factors over here. But what I want is, customary law is a problem area. Woman can get nothing. Woman is owned. What is woman is owned? She is not going to get anything because of the customary law. Is it clear? Say yes.
Yes, sir.
Now the court will give the decision. They see the natural justice is given to her or not. And they follow that law. And sometimes they will deviate it if the justice is not done to the party. So thus they will make things. So it's a big article is there, but you read it, then you come to the class tomorrow. And I sent one Indian writer article also, that also holds good same in Tanzania also. Because the same, we have the customary law, but we codified certain things which are essential. And that is the reason for the Hindus, Hindu Succession Act is there. For others, Indian Succession Act is there. And for Islam, there is a personal law is there. And when the will is made it over there, according to the will, whether the justification is there or not, through the Indian Succession Act, they will check it. If not, it will not be followed. So that was the thing where we can make it a decision. So if you want to hear my Christian inheritance, yes, you can hear. It is based on almost all English case law, the English Christian Act. But now the India is removed over there, the Christian Marriage Act, they will put it over there. So you read this article and you will come to my Monday class, and the gist we can make it out, how the property will be succeeded when one person from one country and another person from another country, how the dispute will be made, and that we will study it. And for the inheritance law in Tanzania, you have to go through all these points. You do have a grip over the inheritance. At that instance, it was easy for me to lead the class, deal the class. So please, it's a very big article, and it runs into the many pages. But you can just scroll it, which are important to you, because this article is where citation is half of the page. Did you observe? See, this 1612 means 612 page, which I shown you. You check the citation. See, actually the matter is, see, up to here only. Only Nussu. And you see the footnote. Footnote is see. It is nearly Nussu, or half of it, or more than half of it. How could you give the citation half of it? No, it is a bad practice. It is a bad practice. No, but Asian or Tanzanian will hate it. It is these people will agree, but I don't know. How could you give the half of the page is only footnote? That means, what is your original contribution? Okay, you are acknowledging. No doubt you are acknowledging. But doesn't mean that half of it is there. You take only few ideas and you incorporate your own ideas. That is the art of writing articles. See, when I observed the article, no, I disappointed. The way it is written, see, how much? Not a single 2 lines we can see anywhere. Not 2 lines. Did you see anywhere 2 lines? I mean, footnote. Did you see a 2 lines?
More than.
You type
More than 2 lines.
You type my name in the Google search engine. My articles are there. You check how many lines are there article. I mean,
Not more, not one.
footnote. Only two lines or 3 lines, not more than that. At the most. See here, I did not say the 2 lines article, footnote here. See. So I'm scrolling one after another to make you to understand. Never write article in that manner, please. It will not have a good opinion about the author. But they feel that if the footnotes are more and the work is more, no, your own idea should be incorporated over there. So that is a very important factor. So inheritance law in Tanzania, that he made it, and I found, and it is written by Tamar Ezer. And who is he? I don't know. This article is a result of the collaboration between the Georgetown International Women's and Human Rights Clinic and the Tanzania Women's Legal Aid Center, WLAC. The initial report is proposed statutes drafted by the spring 2002. Okay, the sponsored one is that's why he has shown as much as he can. So that is the thing. Scholastic Zulu, the project is made possible through the generous support of the, you said, okay, acknowledgement, of course, inaudible information 2002 factoring. I would like to thank my later students who worked other Tanzania projects on inheritance issues in Tanzania, Uganda, and Nigeria, whose subsequent interviews throughout the helped enrich and inform my writing. Finally, a special thanks to Daniel M. Loglin and Oriel Mandita, on whose hard work and insight helped me with this article. So it is a sponsored article, no? That's why they would like to show as much as they can, because we refer the so many sources. Perhaps that would be the idea, it seems. That's why half of more than half is the footnote only, and the original content is only half of it. Okay, you read the three which I posted today, and you have an idea how the issues of the property would be there. And I already prepared the 15 questions, and I will show you and I will post you also the 15 questions. And still time is there to me. Yes, it's time is there. And South and AP and 15 questions. Yes, APL 15. Yes, it is here. Yeah, it is coming out. It's coming out because still it is reading. Yeah. Did you see it now? Read. Read. I said read.
Contemporary issues in private international law. Or what?
Very read. Because only contemporary issues in private international law you said. No, I said 15 important questions for the test for the students of the advanced private international law. Which one you read it? Read the first question. Read the first question.
Why we need private international, and what is the purpose and object of private international law?
See, something is missing here. See, why we need the private international law? Law is missed over there. Of course, it implied. You could understand it. You could understand it. Yes, next. And what is the purpose and object of the private international law? Okay, next. I say next.
What is Prof, I think there's typing error here. It reads, what is the
There is a
importance?
typing error. What is the importance? That is importance. AMPORTENCY. What is the importance of the private international law? Read.
What is the importance of private international law in the present scenario of globalization and liberalization?
Good. Third question. Why other people are not reading? Okay, read. You only read.
What are the main principles of private international law? Support your answer with authorities.
Authorities means cases.
Question 4. What are the connecting factors and how are they important in resolving the private international law disputes?
Good.
Question 5. What theories are applied in dispute resolving under private international law?
There are five theories we taught. Okay, next.
Why there would recognition and enforcement of foreign judgment?
There would be. Why there would be recognition and enforcement of the foreign judgment and its significance in present situation. Or you can say present situation, or we can say in present scenario. You can say present scenario. Okay, next. Seventh question.
What will be the importance, kinds of domicile, and role of domicile in private international law, and discuss with relevant decided cases?
Okay.
How to apply lex causa, how to apply lex causa to the cases in various spheres. Discuss.
Here,
The present, past, and future private
various
international
disputes
law.
we can say. Various spheres means disputes actually. These are various conflicts, we can say conflicts also. Like tort conflicts, contract conflicts, transfer of property conflicts, matrimonial conflicts, Yeah. Deciding the case in various conflicts. Okay, discuss. Okay, ninth question.
The present, past, and future of private international law in East Africa, particularly in Tanzania.
Yes. You
What
can
what
say,
what about
better you say narrate. Narrate will say, narrate. Narrate, N-A-R-A. This is gone over there. Narrate or explain the present, past, and future private international law in East Africa, particularly in Tanzania. Next.
what will be efforts of conventions and other declaration for uniformity of private international law principles?
Okay.
Justify with decided cases to resolve the matrimonial matters.
Okay. Means conflict in matrimonial matters. Resolve the
What is the
conflicts in matrimonial matter. In matrimonial matters. Okay. Next.
what is the role of private international law to resolve the conflicts of law of tort?
Okay. Next.
How law of contract dis- how law of contract disputes will be settled by employing the principles, connecting factors, or theories to settle dispute at the private international law.
Okay.
What measures will be employed for the transfer of property under private international law?
Mm-hmm.
And the final
What
question,
measures and what measures and law would be applied, right? Mm-hmm.
last question, how the matter concerning business and commercial transaction would be handled to settle the conflict under private international law. Discuss.
Compiled by the Professor Dr. Mohammed Saheb Hussain, course coordinator. Is it clear? Why it is not?
What are we supposed to do with the questions, Prof?
Why I am giving these questions? Tell me. Why I am giving this question?
us,
Tell me.
for the second test and also to prepare ourselves well.
That is the important. What I wrote there in the heading, 15 questions, 15 important questions for the test. 2 for the students of advanced private international law. What is the method I apply? You have to sit in front of me in my office or in the conference room or any other place. I wrote the 15 slips. One should have to come, pick the 2 slips. That is your question. You have to write in my presence. Is it clear?
Yes, Prof.
Yes, Prof.
Any doubt? I
The
told you
second one,
guidelines.
yes.
You cannot write 20 pages for one question. Time limit is Time limit is
I don't know, Prof.
what you don't know. Didn't you do in the first semester?
You will.
Prof, may you please repeat the instructions? There was network problem. I did not hear you.
It's a simple question. I make the 15 slips by writing the each question. You have to come and pick the 2 slips which is rolled. That is your question. You have to attempt in my presence. Is it clear?
Yes, Prof.
Yeah.
I heard only 2 sounds. Yes. What about the third sound? What about the
Yes,
thoughts
Prof.
of?
Yes, Prof. It's clear.
Very good, very good. How much the duration?
When are we going to sit for that test, Prof?
Did you see the almanac? There is a clear-cut instruction is there. You have to finish your classes by this time, and you have to submit your coursework marks in this time. So now you decide it. I think I posted you. Did I posted you for your WhatsApp the schedule?
No, sir.
Did I posted you the schedule?
No,
No,
sir.
Prof.
You can see now they are given the clear-cut information to us. Examination deadlines. See, now you can check your WhatsApp. You will know they have given the clear-cut information to us. When should have to conduct, when should have to the last exam instruction day. Okay, now at any time it will be closed. Do you want to ask anything? You can ask me.
Prof.
Yes.
I wanted to ask uh, could we have I mean single day or before the final exams and we do some revision together? All of us three students and you.
Doesn't matter for me. It doesn't makes any difference to me, because if I don't teach, my food will not be digested. Either you come physically, also I teach. If you come on online, also I teach.
Okay, Prof.
But the DVC made a complaint stating that how come that he will teach an online when he's not in present here, because online nobody is having the so and so thing and this thing, that thing. Sometimes the matando, matatizo, and all other things. I heard it.